Hello everybody, Martin Radner here from Radner Law Group. I'm a trial attorney and I'm going to be bringing you analysis today on the YNW trial. Now in this trial, we've got the prosecution rested, the defense rested, and now the closing arguments are going to be set for Thursday. Then the jury's going to get the case, the jury's going to be sequestered, so they're going to be put up in a hotel. No one's going to have access to the jury, so nobody can influence their decision, and that's important in this case because this is a high-profile case and we can't have anybody influencing the jury's decision. So, of course, we will be bringing you analysis after the conclusion of the closing arguments on Thursday, but I think it's a good idea to just kind of take a step back and talk about the evidence that came in and see where everyone is at this point, which will kind of help us, or help the attorneys also, set the stage for what we can expect during the closing argument. So before we do, please like and subscribe to this channel. Again, like I had said, I have a partner that's skeptical of what I'm doing, and I need the channel to grow to be able to show them that actually what we're doing here is important, to bring content like this to the masses, especially content that is from an experienced trial attorney about these very important cases. So let's jump right into it. So we have the prosecution's case. So the prosecution's case can be broken down into a few different parts. Number one, we have the gang affiliation. We have the gang expert that testified that all these signs that Melly was doing and this verbiage that he was using in his text messages, it clearly indicates that he was part of the G-Shine Blood gang, and that is important because the prosecution is going to be seeking the death penalty in this case. And in order in Florida law, in order to have the death penalty, there's a number of different ways that you can be subject to the death penalty, but one of them is if you're associated or affiliated with a gang. If you're associated or affiliated with a gang, even if you're not committing the crime at the behest of the gang, but if you're just committing the murder and you happen to be a gang member, that automatically you are allowed, you could get the death penalty. And therefore, that's why the prosecution had to go and show that Melly was actually part of this gang. So there was no contradictory evidence to that. There were some attempts at the defense to kind of poke some holes in it, but at the end of the day, very strong evidence that Melly is part of this gang. Now, let's get into the other evidence about the actual murder. So we've had the medical examiner, we've heard from the medical examiner, we heard about from the reconstructionist, which showed that there's no question that the fatal wounds came from bullets that were shot from within the car. Again, remember, there's a few different stories that could be said about this case. Either the bullets came from his drive-by or the bullets came from within the car to kill these two people. And the medical examiner's testimony and the reconstructionist testimony was very clear that it had to be that the bullets came from within the car, not just anywhere in the car, but specifically one shooter, and that one shooter was sitting behind the driver's seat. And as the surveillance video showed, that was the seat where Melly got into when he left the studio right before the murder. So some circumstantial evidence that Melly was sitting in that car, and if a little bit later a murder was committed, and according to the medical examiner, reconstructionist, the bullets came from that back seat where Melly was sitting, very strong circumstantial evidence that it was from Melly, that Melly was the murderer. And we've also had evidence of the cell phone data tracking exactly where that phone was, that 9807 number, which is attributed to Melly, and we've had those millions of, seems like, text messages showing that this Melly saying that this phone is his mother recognizing that this phone is his, all of those text messages showing that this phone was actually Melly's. It wasn't shared by 4 different people. It was Melly's phone, and he was the one that's associated with the phone, showing, texting people from that phone saying that it's him, and that therefore, if that's his phone, and the cell phone data shows in that leash that puts that phone in the car, then there's a circumstantial evidence that Melly was with his phone at the time, and therefore he was the one that committed the crime. Now, we had a very important objection by the defense team with respect to these text messages coming into evidence. So anytime you want to introduce evidence, you've got to check off certain boxes. And anytime you want to submit a document into evidence, you've got to authenticate that document. You've got to, basically, you can't, how do we know that you didn't just make up this document last night in your office? How do we know that? So you need somebody, generally, you need a records custodian, or you need somebody to come and testify that this is an accurate document, that the information in this document is authentic. And therefore, one of the very strong objection the defense made is that all these text messages, these hundreds and hundreds of pages of text messages that the prosecution admitted into evidence, or at least at that time offered to admit into evidence over their objection, they are arguing that they have not authenticated that those those documents are actually the text messages that were sent and received to or from Melly. So how are you supposed to know that? How are you supposed to know that all those text messages are authentic? So the defense's arguments were that there's only three ways to do that: either by the sender, whoever sent the text message can get up on the stand and say, yes, I actually sent that message. This document accurately depicts my message that I sent to somebody. Or you can have the receiver of the text message get up there and say, yes, I did receive that message. This is an accurate depiction of the message that I received. Or number three, the only third option, which the defense said, was if you have an engineer, you have some sort of expert be able to testify to the authenticity of that text message that it was sent or received by that number. And their argument was that Detective Moretti is not an expert to be able to testify to that. So therefore, the defense's argument and their objection and their move for a mistrial and all those renewed objections and renewed motions for mistrial were based on this idea that all those text messages were not authenticated and therefore they should not be admitted. The judge admitted them anyway, and therefore all those text messages and the evidence that the prosecution is showing with them, which kind of show that it's Melly's phone, is showing that these certain text messages and what he said. So those were all admitted over this objection. I think it's a very strong appealable issue that the defense will certainly appeal if the verdict comes down not in Melly's favor. If it comes down guilty, they certainly will appeal that issue. Okay, so we have that, and then we also have, which was again the very, very damning evidence, that Melly essentially himself admitted or confessed to the crime by saying, I did that. I did that, and he said, shh, which sounds like I did that. I'm trying to keep it quiet, and that is a very strong evidence. So that was the prosecution's case. That was essentially the prosecution's case. This was certainly not a drive-by. The gunshots came from within the car. It was Melly's phone. The phone was at the scene, and he essentially admitted that he did this crime. Now, the defense, they put up one witness, Adrian Davis, and Adrian Davis testified that Melly was not in the car at all during the murder. He wasn't even in the car. They switched cars. He got into the Mitsubishi car and he went home. And he went home and he went to sleep. And the next day, everybody woke up. They all got the news that Anthony Williams and Christopher Thomas were shot, and they were all crying. And even Melly was crying, and it was so sad. And Adrian Davis testified. He testified also that there was no beef between Melly and Anthony Williams and Christopher Thomas. They're all just great friends, all living together, all just building this brand. And there was no beef and no friction. And that's the same thing also that Travion Glass testified to, that there was no beef at all between Melly and his two friends, and which kind of supports the defense's arguments that why at all would Melly just decide to shoot his two great friends when there's been no beef, no suggestion that there's anything going on between the two. So between all three of them, I should say. So that was an important part of the Adrian Davis of the defense's case, to bring Adrian Davis. Now, also Adrian Davis also testified that Melly the next morning could not find his phone. He couldn't find his phone, which would suggest that even if that phone, you're able to tell by that cellular data or whatever technology you're using to put that phone at the scene of the crime, that doesn't connect Melly to that phone because he lost his phone. It's very possible that that phone was there and Melly dropped out of his pocket while he was switching cars into the Mitsubishi car. So, and also it also makes a lot of sense. It makes a lot of sense that that phone just dropped out of Melly's pocket. Why? Because it's in the middle of the night. Now remember, the evidence was it was in the middle of the night. We have before that they were drinking and they were smoking before they went to the studio. They went to the studio. The evidence is that everyone was kind of just sleeping at the studio, so they all decided to leave. They got into the car. The evidence was that they were all sleeping in the car except the drivers, and everyone was just tired, exhausted, high, drunk, whatever it was. And now it makes a lot of sense that the phone can kind of just slip out of Melly's pocket while he was changing cars. Now, why would he change cars? Why would he change cars? And a simple reason for that is that what Adrian Davis testified to was that there was only two people who had access to that home where they were all staying. It was Cortland Henry and Melly, and those two people were in the same car, in the Jeep. Now, it's possible that the Jeep wanted to make a detour, wanted to take, stop off at a store or something, and the people in the Mitsubishi car needed a way and access into Melly's house, and therefore they had to pick up either Melly or Cortland Henry. Now, Cortland Henry was driving, so therefore they picked up Melly, and that makes sense why Melly would go into the Mitsubishi car and go home so that he can go and open the door for everyone to stay in and everyone to go to sleep. And during that, while he was transferring and switching cars, he dropped his phone in that Jeep. Now, the big problem, of course, with that story is that Melly did send a pin to his friend, and there was some text messages about picking him up. So if he dropped his phone, when exactly did he ask him that picked up? Did he get picked up by Fredo Bang? Did he not get picked up? Was he in the Mitsubishi car? That still leaves a big question mark to the defense's case. If they just want to argue to the jury in closing arguments that Melly was not in the car and he just went home and he went to sleep and he doesn't know where his phone was, the prosecution could say, well, if he doesn't know where his phone is, how did he send out that pin, that location pin, and ask this other friend of his to pick him up? So that would be also something that we can look forward to seeing in the closing argument. So that's kind of where we stand with the evidence. There's been some, again, very strong evidence on the prosecution side. Adrian Davis, I think, was a very strong witness for the defense's case, but again, still left with a number of questions about whether this actually, whether his story is plausible or not. But that's what we're left to now, and now we just have to look forward to the closing argument. So again, like I said, as the closing arguments come in, we will analyze them after Thursday, and we will continue bringing this trial analysis. In the meantime, please like and subscribe to this channel, and looking forward to next time after the closing arguments where we can bring you more trial analysis.